he said, Lloyd, she said, wait 2 minutes, 3 minutes, 4 minutes, 5 minutes. Good afternoon, everybody. We praise God for this wonderful day as we celebrate the legacy of our late Dr. Martin Luther King on this wonderful day. We praise God for the Amistad group that came today to share, to give us as people all over the world information on how to better our lives, to get our house in order. So today, we want to welcome you today here at the Prayer Tabernacle, Church of God in Christ, 3550 Great Neck Road, Amityville, New York. At this time, we get to the hands of the Amistad group. Diane Clark is coming right now. You're in her hands. Tell a friend, tell a neighbor, hit the like button, hit the share button, tell somebody to tune in, be part of this wonderful experience on today. Thank you.
Thank you, Reverend Willie. So on behalf of Amistad Black Bar Association of Long Island, I would just like to welcome all of you, to thank all of you that are here in person and virtually appearing. We have a very dynamic panel for you to discuss a very important issue that, frankly, our community does not give enough attention to. There's always something that pops up in our lives, and we just figured, we'll kick the ball down the field. So, we try to do a day of service every year and diversify the topics, but I'm excited that this year, our 30th anniversary for Amistad, that we are focusing on this important issue. And I don't want to take up very much of your time, so I'm going to turn it over to the panelists to introduce themselves and what they do. So thank you all, and let's give a warm hand to our panel.
Excuse me. Good afternoon, everyone. I'm glad to see you out here. My name is Sharon Hoskins. I'm an attorney practicing in the area of estate planning. And most people are like, well, what is that? I don't have an estate. It's basically wills and trusts and those things that you need to protect yourself and your family. And it's not just about death and dying. It's about living also. So we don't want to forget that part. And I work with my husband next to me here. And we've been in practice together since 2013. And we moved into the area of estate planning about 5 years ago, doing that exclusively. And we're happy to be here to talk to you about that.
Thank you. As I was introduced, my name is Rob Hoskins. I'm the partner of Sharon Hoskins, and I'm just really glad to be here. I'm glad you guys are here on MLK Day so that we can get this information out to our community, because one of the things I will stress is that we are on the precipice of the largest wealth transfer in the Black community ever known. So we're here as lawyers to help you with the legal ins and outs of what that really means.
Hi, my name is Tiffany Kraft, spelled with the K like the cheese. So I have my information at the table as well as in the back. So I always stress and say to people, my hair was better that day when I took the photo. So just a little bit about me. I started my company called Bridge Away for seniors. When you think of a bridge, you think of a guide crossing over in a sense. I started the company, I would say, well, I had a vision. 2017, I was still working as a social worker in a rehab setting, and also doing bereavement counseling as a clinician. And in 2017, I had this vision that when helping people, especially seniors, look for services in the community, navigating, it was very difficult. A lot of times they would enter my doors overwhelmed, frustrated, not knowing what route to go with discharge planning, whether it was from the hospital setting or rehab. So I opened up the business in 2020 where I connect with different resources and providers. So when you think of me, you think of an outside personal discharge planner that has the information pertaining to the issues that goes on in the rehab setting. In a social work point of view, where that's exactly what I do. I navigate the services for seniors and the adult children, especially prior to the discharge date, because it could be overwhelming. So I am that guide, that resource in the community. I service Long Island, New York City, Westchester, Rockland. I have a few cases in Florida, and I just started last year 2 cases in Las Vegas. So I'll be down in March, but it continues to grow. So again, Tiffany Kraft, your personal discharge planner.
And a lot more with that. My name is Jocelyn Gums. I'm with Avanti Healthcare. I am probably not truly connected with everyone else here, except for that we do medication. So if someone's taking more than 5 medications a day, we do blister packs where it's delivered, pre-packaged and delivered to the home. And someone's like, well, why would I need that? Because like something Tiffany stated, and even with the Hoskins, with healthcare, things change. And the goal is if you want to stay in your home, to stay in your home. If you need Tiffany to go into assisted or independent living, we can support you in that way. But what really has me up here today is that I see it in our community and different things, how we can plan ahead and be proactive and not reactive in my job. And that's why I do work with the Hoskins, Tiffany, and Clint. And again, Jocelyn from Avanti Healthcare, and I also have information if anyone needs it.
Okay. Hi, everybody. I'm Clint Georges. From the attorney to Tiffany to Jocelyn, who said she's not important, but she is, because pharmacy is one of the most important parts of all of it, right? Because once you go home, you need to make sure you have what you need at home to make sure you're safe in your home. That goes to me. I'm an administrator of a home care agency, but before that, for many, many years, I was on the insurance side of the thing, of all of this, from the attorney. From first, when I got to home care, I wanted to learn how did a lot of people that didn't look like me had home care. And then I met attorneys. So they're very, very important. Then you need Tiffany, who bridges the whole entire thing, because without an advocate, you won't get everything you need. And then with the advocate, then you have to go somewhere. So I went to that side, because I know all three sides. And Jocelyn, the most important, my mom's pharmacist. Without you, there would not be what the patient needs. So please, let her be modest. And hi to everybody again.
I guess because I'm the baby in the group, huh?
So I know that some of you have been have attended these presentations in the past, our legal clinic, but this year we decided to do something different, and by focusing on this one area. One thing that Pastor Willie emphasized is that, you know, the church has always been a source of information, with a safe place where people could go and find out how they could handle their business. Good afternoon, Legislator Rick Berg. So that's what we're trying to do here today. So what I did was I wrote a hypothetical, because these are some of the issues or scenarios that I have encountered in my 25 years of being in the legal field. And a lot of times people think that these are really not big deals, but you could see how these issues could snowball and create what we like to call a hot mess. So what I'm going to do is I'm going to read the hypothetical in parts and allow the panelists to jump in when it's something that would involve them. So starting off, I'm just going to give you some background information about our people. So Bertha Brown is 72 years old. She's never been married and lives in a 6-bedroom colonial home in Somerville, New York, with her 93-year-old mother, Mary Brown. The home was built by her great-great-grandfather in the early 1920s. Also residing in the home are Bertha's 2 adult daughters, Anastasia, age 45, single, no children, and Keisha, age 42, married to Derek, age 44. Keisha and Derek have 2 minor children, Nevaeh and baby D, who's 18 months old, and Nevaeh is 7. The home is a single-family residence owned solely by Bertha. No one else is on the deed. Bertha also has a life insurance policy of $100,000, naming her daughters Anastasia and Keisha as beneficiaries. Bertha's mother has limited assets and receives Social Security. Until 2023, and remember today is 2026, the home was owned by her mother, Mary Brown. Mary wished to sell the home to her granddaughter, Keisha, and her spouse for less than 50% of the home's fair market value to keep it in the family. However, Keisha and Derek were unable to qualify for a mortgage. As a result, in 2023, Mary transferred the home to her daughter, Bertha, who was able to qualify for financing. The home is titled solely in Bertha's name with a life estate for her mother, Mary Brown. Keisha and Derek pay the mortgage and property taxes. Anastasia pays gas, electric, and water. Bertha provides daycare for Nevaeh and baby D and food for the entire family. The Wiggins, that's Keisha's last name. Keisha and her husband installed a new heating system, updated the electric, repaved the driveway, renovated all of the bathrooms and kitchen, installed vinyl siding, and fixed the masonry work and installed the fence. They also legalized the attached garage built by their grandfather. Dun, 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 dun. Mary Brown, that's the grandmother, recently fell in the garden at the family home and broke her hip. She is currently hospitalized and scheduled for hip surgery. Upon discharge, physicians anticipate that Mary will require extensive physical therapy, subacute rehabilitation at a skilled nursing or rehab facility. It is also possible that she may to transition to long-term nursing home care depending on recovery. So let's start with Mary. So now she fell, she's in the hospital, and she had the surgery. Where are we now?
So she fell, she's in the hospital, she had the surgery,
And
she needs a rehab.
Yes,
So we're gonna focus on Mary right now.
right.
Okay. So, when you're listening to this scenario, Mary, if it's her first time in a hospital setting, Mary has...
Yes, because she ate her vegetables every day
Okay.
and did Tai Chi. So she's a very healthy, vibrant, spry 93-year-old. And I want to say that because sometimes we see these octogenarians and centenarians that are getting around good and we think that they'll never have an issue. And so I want to throw that in. She eats carrots every day and
Okay.
juices too.
Okay. So, in my world, I'm Tiffany Kraft again. In my world of how I think, my brain just goes because I have two parts of me. So as you remember, I said I came from the world as a clinician. So I'm always thinking about the statistics of a person when it comes down to their mental health. That's really not talked about a lot of times in a church setting from where I come from, unfortunately. So you have Mary, elderly woman. I think of CEW. CEW is the Q factor. The Q factor stands for confused, exhausted, and worried. Because if you have a scenario of an elderly woman who's the first time in a hospital setting, maybe the first time having surgery, possibly transitioning to a subacute rehab setting for rehabilitation.
What's subacute?
Subacute is short term. So when you hear sub, short, SS, short term. With the overall goal, if Mary wants to return home, she is probably worried about what's the next steps. So here I come in as the middle person where I help navigate for Mary only right now. I'm focusing on Mary, and I'm trying to figure out Mary's wants versus her needs. A lot of times, people don't even know what the nursing home subacute places look like. They've never toured it. They've never looked into figuring out what the availability is for their potential needs. So that would be me as navigating information for Mary. So therefore, she doesn't feel what? Cued. She doesn't feel confused. She doesn't feel exhausted. She doesn't feel worried. That actually helps decrease the feelings of depressive symptoms and feelings of anxiety. I'm a statistics girl. So I have, if someone can answer this for me, I have a gift card for you. You ready for it? Okay? So now we're going to focus on Mary again still. What's the percentage, okay, of an elderly person annually in the United States that suffers from falls annually? About how many people, you would say? Okay, so in the numbers form, what does that look like? Is it 10,000 people? Seniors now.
1 million.
Okay, you say 1 million. Anyone else? Annually, yeah. Any elderly between, 65 and older. Okay. 5 million. Anyone else? Okay, 100,000. One more to go. Anyone else? 75? Okay. Annually, statistically, there's about 14 million falls.
Wow.
And older adults, okay, every year. So, ding, 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 the gift card goes to you. So that's where I come in. I'll pass the mic, but with me focusing as the discharge planner, I will help Mary identify her wants versus her needs. Mary, I know you want to go home, but what do you need? And then from that, I help her navigate whether it's a subacute nursing home rehab setting or to go home with home care services, or if she actually really needs a long-term stay in a nursing home level.
Okay. Well, I was getting ready to,
Okay.
you reading my paper. So this would be for the Hoskins. So since she has a life estate in that former home, do they have to sell that house to pay for her to go? Because let's assume that she's going to go to the facility. She's going to go to a long-term nursing facility. Do they have to? Does the family have to sell the house to pay for her care?
Well, the short answer, and what most lawyers give, is it depends.
Remember, she has a life estate established in
life estate.
2023.
Right. So she may not own the house, but a life estate does have value. So what Medicaid is going to look at is we're going to determine what the value of that life estate is, and as far as her assets. So you have two criteria, right? When we talk about applying for Medicaid, you have the financial and the medical. So the medical side is a qualification, but on the financial side, you're looking at the income and the assets. So right, that's what we mean by resources, are your assets. So her assets, Social Security.
A little bit. She's getting her husband's Social
Yeah.
Security, who died 40 years ago. She was a young widow.
Right. So
She gets like $1,000 a month.
$1,000 a month on the income side. So she's under the threshold, which is currently right around $1,800 a month. So she would qualify there. Now on the asset side, now here's the thing, she sold the house to Bertha in 2026? Three? Okay, so 5 years hasn't passed. So when we're talking about that 5-year look back, in terms of a long-term nursing home care, if you're applying for that. So there's two different Medicaids, let's say, that you can apply for. There's community Medicaid, where you will be staying at home with a home aide coming in, or long-term care Medicaid, which is the skilled nursing home facility. So the 5-year look back applies if you're applying to the skilled facility, long-term care Medicaid. Okay? So since she transferred that within the 5 years, Medicaid is going to say, okay, we'll qualify you, but there's going to be a penalty. And that penalty is applied as a formula. So we have to value the value of the property that was sold divided by the average cost of a month's care in a nursing home, and you get a certain number. Let's say, for example, it's 10. You have to pay for the first 10 months of care, then Medicaid will begin to pay your long-term care at the facility. So that's a penalty that would have been triggered there because of the transfer.
So this is not in my hypothetical, but I want to just throw this in.
Mm-hmm.
If the date of transfer would have been 2019, then she wouldn't have to worry about the look-back
Right.
period.
So if you want to take it back and you don't have the 5-year look-back period to worry about, the transfer was done, then the only asset that we're considering is the value of the life estate. So, that typically doesn't come up that often, but the value of the life estate can vary. It has to be considered how much, what's her life expectancy versus what the market rate is for, rental, owning that home. So
Awesome.
it'll be a lot less, but, so typically we don't encourage that to be done. So if you're transferring a home completely, if you're selling it, that's fine. Or you can put it into trust for someone else to protect, so that you can still maintain, living there and not having to move or anything really changing in your life.
All right, let's move on. So, we said she had a successful hip surgery, and she was discharged from the hospital and transferred to Boondocks Rehabilitation Center, located approximately 75 minutes from her home in Somerville, New York. The transfer was arranged by hospital discharge planners based on bed availability, not the family preference. In order for the family to visit Mary, they must travel 75 minutes daily from Someville to Boondocks. Can you talk about that, Clint? Like the choice? Oh, okay. Can you talk about that?
I'm the bridge.
You're the bridge, okay.
Me. Okay, here we go.
So just to crystallize the issue is, the real issue is, who gets to decide where you go if you have to go for nursing care?
That depends. It
Right.
depends. And a lot of times people will, in the hospital, I used to do it. I was social work. I would give a list, pick your top 3 places, and according to your insurance, if it covered. All right, if you were stalling, I'm only speaking just based on from what I used to do for 15 years. That's why I talk like this and I look like this. You know, I would say we could discharge you within a 50-mile radius. So, and then we would also issue you what's called a cut letter. So let's say if she didn't want to go, Mary didn't want to go because it was too far, right? Too far, family couldn't visit, things like that. If the insurance stopped, that's a question that sometimes a lot of people don't know about what their Medicare or managed plan covers. If the insurance exhausts, I would assist Mary on looking at options here. For example, if she didn't have to go 75 miles, right? So, but if she did, I would look at, number one, what the insurance covers, right? So a lot of times with a managed plan, Medicare, if you're 65 and older, more than likely you have Medicare or a managed plan. We would look at if she was able to come closer or not. It also depends on the insurance, if there's authorization for her to go somewhere according to her needs. So
But she and her family are allowed to have input, is that correct?
Mary is allowed to have input as long as she's deemed with capacity. Now that's a question people ask, what does that mean? If the hospital never deemed you with no capacity and you're a 90-something-year-old woman and you still have capacity, you have all say. You have a say if you want to go home to the rehab or go into a nursing home. The daughter, seems like the daughter is the number one person who's involved. She has a say so too. So everyone that's involved in Mary's care, Mary being the primary person, has a say so in it. So just because social worker passes that information saying that, you're ready to be discharged, doesn't mean that she has to go. Discharge planning happens 3 different ways. It's either home, assisted living, or nursing home level. And so a lot of times these are the questions that sometimes people don't know how to navigate, and because I do, I become that voice for those types of scenarios.
All right, let's throw the mic to Clint and see how would this change if she was being discharged home? Like, what would we have to take into consideration?
That would be a Tiffany question still, but
Oh,
first,
wait. So what do you do?
I'll answer because I know, but it still would be a Tiffany question in the future. But before they go home, I would ask, have you exhausted your child services? We'll see what Medicare can cover first. There you go. Charge for short term, so you're going home automatically per year. You're allowed 4 months of up to 20 hours a week. They're only going to give everyone in this room, no matter who you are, 9, unless you have Tiffany or Clint to advocate for you. They won't give it to any of you. They didn't give it to my own mother, and then I had to call and say, look, you're going to give her 20. So automatically, Medicare only going to approve 9, like she said, if you're lucky. 6 if we like. So then
a week?
Yes, per week.
Oh.
So now we have to use that 6 and bridge it with something else. Hopefully the attorney finished and we can help you apply for Medicaid. Or Tiffany started the process. Go ahead, ask your question. Pink shirt behind Jocelyn's lovely sister.
No.
Let's go back.
I'm sorry. I wanted you to go back. Either you were talking too fast or I wasn't listening.
I apologize.
I didn't understand when you said the 9 weeks.
9 hours.
Oh, 9 hours.
9 hours a week. We're up to 4 months per year. Go ahead. So
we're going to go like this, because I need everyone on this panel when I help transition someone to the 3 different levels. Okay, so let's go back a little. What's CHA? CHA service stands for basically it's home care provided by your primary insurance, Medicare or managed plan. And a lot of times, I'm going to revert back to when I used to work, I would say to them, listen, You know, when you're discharged, let's say home, Medicare is going to cover about 1 to 2 times a week for a nurse, that's usually an RN, 1 to 2 times a week for a physical therapist in the home, 1 to 2 times a week for an occupational therapy to help with your fine motor skills, 1 to 2 times a week if you have speech issues, if you had issues in the rehab setting, it will continue on, right? And maybe a shower aid, maybe, because a lot of times it takes within 24 to 48 hours for home care covered by Medicare or your primary insurance just to go into the house. And if you're discharged on a Friday, good luck for the weekend, right? So here's another statistic and another gift card. Ready for it? Oh, sorry. I have 3 total. Okay, here we go. Statistic. What's the percent out of 100% of patients that are sent to a rehab, right? Short-term rehab, but readmitted within 30 days? What's the percent out of 100? 100%?
80%.
80%? 100%?
100%. 75%.
One more guess?
Any more guesses? 60%.
60. No more guesses?
50.
All right.
I think we got every number now.
Okay. 25%.
Oh, okay.
However, it's 1 in 4. Yes, 25% within 30 days. But the issue is it's still a percent. So whoever was the lowest gets a gift card.
Who said 40?
Someone said.
All right, here we go. Thank you. All right, so. Oh, you didn't say anything? Here you go. Who said something? Here you go. Okay, there you go. All right. Let's gonna move on with our.
When she goes home, right?
Yeah, no, you don't.
Everyone hear me.
Well, you need it for the Zoom. Yes. Okay.
Okay, so when she gets home, like Tiffany said, those hours, it's very true. You go home on a Friday, you may not get any help. You might have a nice agency and say, look, we'll come in, we'll attempt to bill for the weekend. But you have to guarantee that home care agency you're going to stay for the weeks. And hopefully when you do get the Medicaid, they can recoup it. Sometimes, depending on the agency, they will help you on the weekend. Because it's just help, because it's a liability for them. But we have a lot of times, families do not know what to say, what to ask, especially on the discharge, on a Friday. Because you can make sure you have help by asking the right questions if you had a Tiffany, right? And an attorney. Me, myself, I apologize. I will no longer ask that question because I can't. Because as an administrator of a home care agency, that's cherry picking. But I can tell you from my other side, the insurance side, everyone in here can get help no matter who your insurance company is. But it's how you get that help. You have to ask the right questions, the trigger words they need to hear, right? Mom goes home, she will fall. I have 4 steps. How's she going to get inside? Once they hear steps, she technically can't go home. So what's next? You have to say the right things. So when we say these things, we have to understand that we just don't know what to say. So when your attorney plans for the future, state your home's demographics. I have 4 steps to walk in. The bathroom doesn't have a shower. We have a tub. Tub means, wait a minute, Warrior lift. All these other questions now exist. It triggers other things that Tiffany can help you with. Now, what's the next hypothetical for Mary, besides losing the home, possibly?
Just for on the attorney side. So, for example, let's say if Mary did go to the nursing home, right, for a few weeks, I always say, while she's there, and this will be for the daughter, but while she's there, get things going. So, for example, that's how I connect the clients and the families with services such as this panel here. And the first question I ask someone is, your mom is 91 years old. Does she have any advanced directives in place? And they're like, advanced directives?
Don't spill on the next part.
Oh, so but this is an example. Someone like all of us on this panel, they would be my guide to be able to text to revert back to, so attorneys can help patient and family.
Okay, because we all know that when it rains, it pours, right? So, One evening, while returning home from visiting her mom, Bertha was wondering if her mother would still be in the rehab center after she travels to Somalia in June. Bertha has traveled to Somalia for 45 days annually since 2010. Out of nowhere, a truck enters the Southern State Parkway erratically and pushes Bertha's car into the overpass, causing her lung to be punctured. She sustains additional life-threatening injuries. She is rushed to the hospital and placed in critical condition. At the hospital, Bertha's children are informed by physicians that Bertha is a good candidate for a lung transplant given the trauma sustained to her lung in the accident. The children do not agree on whether Bertha should undergo the surgery. I meant to say that she was placed in a coma. So, I want to add one more thing. In addition to her 2 daughters that live with her, Bertha had 2 sons, Alfred Brown, who's still alive and lives in Maryland, and Malcolm Brown, who died due to COVID in 2020 and has a young child. So, now Bertha's in a coma, her mother's in rehab, the doctors are talking to the children about surgery. Who has authority?
Okay, I'm glad I've been wanting to go back to the hospital from the start of this, right? Even with Mary, because we didn't talk about the healthcare proxy. Anytime someone goes into the hospital, one of the documents that they shove in your face and tell you to sign is a healthcare proxy. And we always say, don't sign the healthcare proxy in the hospital. You need to prepare one before you ever get to the hospital so that you can customize it the way you want and need it to be. And that means you select the person who is going to be responsible for making healthcare decisions for you, making those medical decisions, conversing with your doctors. If you have capacity, then you can still make those decisions. But if you are a little in and out, but you have a family member or whoever you chose, they're the ones that's there to advocate for you and carry out your wishes. Not their wishes, your wishes. And so that's why it's important to have that healthcare proxy done in advance while you're still, not in an emergency situation. And you have accompanying that a living will, not to be confused with the last will and testament. That's something else, right? But the living will are the instructions for your healthcare proxy as to what you want concerning end-of-life care or even just emergency care while you're in the hospital if you're undergoing surgery or something like that, and what you're willing to receive in terms of those treatments. Some people are very, very clear that they don't want to be resuscitated. They don't want to be intubated. They don't want to be on a ventilator. And that's important to know. So if, who's in the car accident?
Bertha. Poor Bertha.
If Bertha, I have to, as an aside, you remember that song back in the day? Bertha Butt Boogie? Remember that? Okay. Sorry. Anyway, I can't get that out of my head because she introduced that fact pattern. But Bertha is, now I lost my train of thought.
She's in a coma.
She's in a coma. And if so you don't know do we know what she would want to happen, right?
Well, let me throw some, what do they say, a fly into the ointment. She has no healthcare proxy. So now who has authority?
So now no one has authority. They have to go to court and get a guardian appointed for Bertha. That's a process. Right, and that is a process. It involves money. You're going to need to hire a lawyer to make the application to the court. The court then will appoint another lawyer to look out for the interests of Bertha, because that family member applying may not necessarily have Bertha's interests at heart, because they might be trying to get at her belongings or whatever, or her assets. So the court is then going to decide whether or not, A, does she actually need guardianship, and B, if she does need guardianship, who should be that guardian? How many think it's going to be Bertha?
Well, no, Bertha's
I'm sorry, not Bertha. How many think it's going to be the family member? Let's say it's her son.
The next of kin.
Then, well, it doesn't have to be that. Anyone can make the application. Anyone, and I mean anyone. It doesn't have to be a family member. Wendy Williams, you know, her situation.
Yeah.
You know who made that application? Her banker. Her banker.
Doesn't mean that that's the person that's really looking out for your best interest.
Exactly.
The person that
Takes the initiative.
taking the initiative.
So I think it's gonna be Keisha, the daughter that's married and they pay the mortgage and everything. I think she's gonna file.
Well, hopefully, that would be her
One
daughter.
of her daughters.
So hopefully she, you know, is the one that made the application. But my point is, the judge does not have to appoint the person that made the application. They can appoint whoever they determine is the most suitable for that role. So it's not a given that it's going to be the person who made the application or that it's going to be a family member. So that's why you want to avoid the whole guardianship process altogether by simply putting into place two documents, your healthcare proxy and the power of attorney. The power of attorney is the document that appoints someone to take care of your legal and financial issues. So if you are incapacitated in some way, even temporarily, or even just unavailable, right? It's used a lot in house closings because the person can't be present. But you want to appoint someone that you choose, and it's legally binding, and you know that you're going to be taken care of the way that you want to be because you set that up.
Okay. So no healthcare proxy, no living will, or advance directive could be located. Despite the disagreement among the children, the hospital proceeds with the transplant. During surgery, a surgical assistant administers the wrong IV medication, effectively poisoning Bertha. Bertha dies during surgery. The death is later determined to be a result of medical error, giving rise to a potential medical malpractice and wrongful death claim. Who has authority to file that?
Well, no comment on the medical malpractice claims or wrongful death, but in order to be a representative of the estate, somebody would have to be named as the administrator of the estate. So after her passing. So now that's a whole nother issue. So the same issue in the guardianship scenario can still come up post-death. So one of the children says, well, I'm the oldest, I should be the administrator, so I'm going to put in a petition. Well, guess what? You go to surrogate's court, the rest of the siblings and other family members are notified, and they can say, no, I don't think my sister should be the administrator. I should be the administrator. Now what do we have? We have a contest. We have litigation. So now the court is going to say, okay, we've got to determine, somebody's got to be the administrator of this estate because there's assets, there's a wrongful death claim and so forth. And so now we're going to have litigation. Yeah.
Explain the difference between administrator and executive.
Right, okay. So I was going to, yeah. So the one thing to be clear about is what the process is after somebody dies. If you have a will, right, because then you might say if she had a will, where in this case she didn't.
She has no will.
Right, so that's when your death is what's called intestate. So that means that there's no will, and an administrator, it's called an administration in the surrogate court. So that means somebody has to administer the estate that's left. If you have a will, if you did a will, and there's somebody named as the executor in that will, that's called probate. And that means that the will, the physical document, has to go to the court, be authorized, right, and be proven to be the original will. And then the court has to appoint or approve the executor to be appointed, right? And it's called, what the judge does is that they once all of the documentation is in, and if it's not contested, then you are issued letters testamentary, which gives you the authority to go to banks, to represent the estate and collect all the assets and so forth and so on, and represent the estate in a wrongful death or medical malpractice claim afterwards.
Okay. So now, after Bertha's death, her children disagree about whether Bertha should be cremated and a memorial service held or have a traditional wake and funeral at their family church. Each child indicates their mother told them her final wishes, no will has been located. What happens there?
That's a tough scenario. So this does happen because sometimes people convert to different religions or they marry somebody that's, so this is where a next of kin really has more standing in the decision making. So somebody passes and there's no, question about it. A surviving spouse is typically the first person that's authorized to receive the remains and direct what happens. Not the parent and not the children. So the surviving spouse has that hierarchy of right. What we do is you can also have a disposition of remains so that you can appoint somebody to take possession of the body, indicate what funeral parlor they're going to use, what the desires are. So you can do that as well. You can, no, that's not in the will, in a separate document. Just like, yeah, in our planning. So in the will, you can state, your desires, but you may not find the will until months later, so you don't necessarily know right away if the will, some people put their will in a safe deposit box. So, by the time funeral arrangements are, and all of that back and forth is going on, you may not find the will to find the desires of the decedent.
So in our hypothetical, it's believed that Bertha is single, and so she has 3 living children and 1 child that's deceased who has a child. So for all intents and purposes, she has her mother, her 3 children, and her grandson. Who is considered the next of kin?
It would be her 3 children if she's single.
If so, all 3 children would have to agree?
All 3 children would have to agree. And if they disagree, then they would have to go to court to get an order to determine which course of action is going to be taken.
More money on the inheritance.
Mm-hmm.
Exactly.
More money on the
Exactly. And it can be avoided by a simple document, called the disposition of remains agent, appointing the person who's going to be responsible for, if you want to be cremated, make sure you get cremated. If you want to have a funeral and you want white doves to be flown and all kinds of things, you want to parade through the street, and these are real cases. I have clients who ask for that. But if you want that, you put it in there, and your agent is tasked with carrying that out.
That's why it's so important from day one, we're going back to Mary really quickly. It's Mary in the rehab. That's why it's so important. If Bertha was alive, right, and let's say she met with me, from day one, when her mother entered the doors from a hospital setting, if she didn't do it at home, or in a rehab setting, I would connect her with resources in the community so they can come to her. Because go back again with me, when I mentioned the Q factor, I created CEW, which is acronym of confused, exhausted, and worried. You can get that from also the daughter, Bertha. Before Bertha got hit by the truck, Bertha was probably feeling confused, exhausted, and worried, right? So a lot of times I always say, I meet the client where they're at. And the reason why I say I meet you where you're at, because I think of adult children that have elderly parents. They're the baby boomers. They're the middle people. They're the sandwich of the relationship when it comes down to their own needs. They may have their own grandkids now. Now they have to deal with mom or dad who's still alive. So it's something called caring for the caregiver. And a lot of times we forget that, because at the end of the day, the caregiver can burn out before the person or the client that's in the hospital or the rehab. Again, I'm a statistics person. Over 74% of caregivers burn out. So here we go again with the statistic. I have one more gift card for you, all right? Speaking of caregivers, if Bertha was alive, even though she's passed on, let's look at the statistic of a caregiver. Okay, who can tell me what's the percentage of caregiver burnout? What's the percentage of caregiver burnout when it comes down to experiencing anxiety or depression or feeling overwhelmed? Okay, 75%.
You can't win if you're on the panel. Anybody in the audience have an answer? Gentleman.
Burnout. No, burnout with the
Gentleman
mental
in the
illness.
last, with the hat on, what did you say? He said 60. Anybody else? 45? 30? 38? Oh, Pink said 80. Mr. Gum said 75.
All right. So we're talking overall, like mental health, depression, anxiety, things like that. 60%.
So was that you with the gray hat?
About 60%.
60%. All right.
So, yeah.
Okay.
Just kind of going back to what Sharon and Rob and Tiffany was saying. So, again, I'm on once you get home, right? I'm the medication, and I'm gonna call FIC. But we all been there. You visited someone in the hospital. You visited someone in the rehab. So with Bertha and Mary, the conversation should have started when she was in the hospital with the surgery. What is the long-term goals? And that's when you could have started talking to Sharon and Rob, right? To say, you know, we don't have anything in place. What should we be doing? What should we be looking at? Oh, okay, I'm still confused. Okay, let me give you to someone else who can really handhold you. Because we know they're busy. They can't answer 1,001 questions, but they can take care of the legal questions. Then you can call into Tiffany and say, we're trying to figure out what's the best options. So again, these things do not have to become a big snowball, because you can nip some of them in a little bit of bud by having I know they happen, I know, but I know, we're going to get there, I promise.
They did. My question was just about who has the right, but finish. And
so I think that the goal is that we're trying to connect the dots so everyone can understand that some of it does not have to happen this way by just having a simple conversation to understand what is available to you.
And I think that one thing that Rob and Sharon brought up that was the first time I ever heard of it, about the disposition of remains, because sometimes you might not be ready, to say who's going to get your house, who's going to get your jewelry, who's going to get your furs. But you do have like a clear vision of how you want to be laid out, right? Like, you know that you want to be buried at your family church. You know, you've been a devout Christian. You want Christian traditions. You want an open casket. You don't want an open casket. You want to be cremated. And so it could be done independent of the will.
Yes.
And I think that's very important. If you have that in your mind already, like, no way am I ever going to be cremated, then you need to write that down. That's what I'm hearing. All right, so it's getting hotter. It's getting hotter. So remember, the children are fighting over what is going to happen for the farewell for Bertha. Before any decision is finalized, a man named Yusuf Mohammed appears at the family home in Sumville. Yusuf Mohammed produces a Somalian marriage certificate showing that he and Bertha have been married since 2010. Yusuf states that he has dual citizenship in the United States and Somalia. He and Bertha maintained a private marriage, and he is her lawful loving spouse. He further states that he is a practicing Muslim, and Bertha must be buried according to Muslim tradition at sundown. He further announces that he intends to move into the family homestead, and that all occupants have 60 days to vacate, and that the grandmother Mary cannot return after her rehab stint. He intends to move his other wife and children into the home in Sumville. Now remember, Mary's grandfather built this house, so this house has been in their family for over 100 years. The children assert they never knew Yusuf, dispute the marriage, and refuse to vacate. That's the ball of Rob and Mary, Rob and Sharon.
Judge Gums is writing the bar exam questions, because that's a lot. So, assuming that this marriage is legitimate, we're going to assume that that's the case. Then
With no will.
There's no will, right. So, the family has a lot of problems right here because the surviving spouse has hierarchy. So let me just go back to one of the, right, and Bertha's the only person on the deed. So let me go back to when I talked about intestacy. When that happens, and we talk about next of kin, so there's a list in the law. So it's, so when the first person that's on that list is the surviving spouse. Then it's children. If there are no children, then it's parents, and then on down the line. So in this scenario, if he is the surviving spouse legitimately, and there's really not a way, I don't know, well, you can answer this question. If they can challenge the legitimacy of his marriage, that's an entirely different issue.
Well, remember though, if there are children, the surviving spouse doesn't get 100% of the decedent's assets, the person that died's assets. So the new Somalian husband does not get 100% of that house. What he's entitled to is the first $50,000 of her estate, and then plus half of everything else. The other half goes to her children, and there were 3 children. So
And a grand.
But it goes to the children,
Okay.
right? The living children, and so they will have a say in that house. So now, and let's go back to his idea that he was going to move in his other family into the house and tell everybody they have to vacate in 60 days. Remember, Mary has a life estate. Mary is alive. So Mary has rights to be in that house as long as she stays alive. And so that brings us back to Jocelyn over here, because we want to make sure she has her medication straight so she can stay alive, right? We want to make sure that we're going to go to Clint down here to make sure they have caregivers that are coming in to service her while she's living in that home so she can be there as long as possible and her other children can live.
And then you have
Oh, wait, before you go, I think we just have one question.
One question. Does it make a difference the fact that the deed was transferred 3 years after the date of the alleged marriage? I think you said that.
No, it was like 13 years. He's saying that they got married in 2010. The deed was transferred in 2023. So it's marital property in New York.
Well, yes and no, but it has nothing to do with her dying. If they were going to get a divorce, then it would matter. But it was gifted to her in her name only, right? The question is, did she pay for any of that? If she didn't pay for anything, pay to receive that house, if it was just gifted to her.
But she took out a mortgage, remember?
But it would have to be decided, right? Because my point is this. If it was given to her and she didn't use any of her own money, which would be considered marital money, to purchase that house, then it's her separate property and she gets to keep it and he gets no part of it. Because remember, he wasn't living there at all, so he made no contribution to it, to its upkeep and maintenance or anything. But now, was it she that took the mortgage or the other?
She took the mortgage out in her name
I
because
thought-
she had better credit.
But I thought the sister and brother were paying the mortgage.
They were paying the mortgage.
Okay, so there's no contribution from her. See, this is going down another road of matrimonial law,
but we have to
which
go.
we practiced for 20 years.
Yeah, but we have to go down this road.
Right.
The reason why, and there's something else I'm going to bring up as well. The reason why we have to go down this road is because, I will say that Black people have a different way of relating to one another. And I have seen it on more than one occasion where people, stopped living together 25 years ago, done had kids with somebody else, living with somebody else, they've been together, traveling together, whatever, and then when they die, people get put out of the house that they've been calling home because the person is still never divorced. And so when we say protecting your legacy, this is also part of protecting your legacy.
Right.
And,
Talk about what she should have done.
yeah,
So, I know how constructive trust work in the marital realm. When we talk about divorces, is this another instance where a constructive trust would be argued by the family members? She got it as a
It could be argued for $25,000. Okay, so and that's something that I want to just kind of point out why we're also talking about advanced planning, because every single issue that came up here, you could most definitely litigate, but there's not a lot of entities that litigate for free. So unless you have 10, 15, I think one of the most recent cases that I'm aware of a contested will ran one party, one sibling, $45,000, and they still didn't get they felt like they should have been getting like a full third of their parents' home. They still didn't get the full third. So it cost them $45,000 to get less than half of what they thought they were going to get. So instead of them accepting the $150 from the jump, they still got the $150, which was within the will, and minus the $45,000 that they paid to their attorney. So, that's why I want to just bring it up, because it happens a lot that people think that they're free and single or whatever, or that they created a new marriage or a new life, and they haven't. So
Right.
good.
Oh, absolutely, Judge, because what you're bringing up is the critical point is what people have to understand is that when you're talking about marriage and we're talking about wills, we're talking about legal connection, right? So when you get married to somebody, that's a legal contract. And if you don't have a written contract, the state law where you are is what applies in that contract. So what she's saying, when somebody's married and you move away and you separate and you don't ever bother filing the divorce, there's so many things because you're still legally connected to that person. And let's not even talk about post-death. Let's talk about your pension. You separated in your early 40s. You couldn't stand each other. One of you moved, and like Judge said, that you established another life or whatever. But now you retire, and you're taking your pension. And somebody gets in your ex's ear and says, "Oh,
that would be me.
You don't
Girl,
have-
you better get that money. That's gonna be me."
Guess whose pension is getting cut? Because now there are some parameters there, because if you're not together and all this other, there's different things, but they're going to be entitled to some significant part of that pension going forward while they're retired. So that full $2,000, $2,500 a month that you were expecting, it might be less 500 because now it's going to your spouse because they're still a spouse, right? So you get divorced.
Beforehand.
Oh.
Okay, I just want to bring up one other thing out of the hypothetical. So now the kids want to fight Yusef, right? And so the son, Alfred, says to his two sisters, "We're going to use the life insurance policy that mom left you to fight Yusef." Do they have to do that?
The life insurance policy was left only to the two sisters, right?
Correct.
No, they don't have to do that. They can say, "No, I'm taking my $50,000 each, and we're going about our business."
And
But
does the life insurance policy have to go through the court?
no. Life insurance, it has a beneficiary designation on it. It goes directly to that beneficiary. It does not have to go through probate, which is the court process. So you get it free and clear.
I just want to take a moment to just take a step back on this happens. This is a real thing, right? Not necessarily Mary and Bertha, their names, but while there's conflict and battles happening on the outside, guess what's happening on the inside? Mary's still in that rehab. Guess what's happening to Mary with her insurance? clock is ticking, right? So I always say, time is money. And the reason why I say that is because you know your insurance. More than likely, you either have, Medicare, managed Medicare, things like that. And so a lot of times, I can guarantee you, when Mary entered that rehab, if she didn't have someone like me whispering her ear, if insurance covers. So let's say she's been there now 3.5 weeks, and family's fighting, battling, court. This is the legal team here, right? So now she's out of pocket. Mary's accruing a bill while she's in a rehab just for a short stay. Do you know your Medicare? Do you know what it covers? I can guarantee you most of us in this room either have been in a hospital, a rehab stay, or know someone who's been in a situation where the social worker goes to the room and says, all right, Medicare now says you have to pay 2025, 26, you have to pay about $200+ a day, 3 weeks after being in a rehab stay, because your insurance doesn't cover. But if you knew beforehand, that's why I always say discharge planning happens from day one when you enter those doors, whether it's a hospital or a rehab setting. So therefore, I can grab the team and we can be proactive, as Jocelyn said in the beginning, instead of reacting at the last minute. Because at the end of the day, while the family is fighting here, Mary is still with it in a sense where she can dictate where she wants to go, right? But the issue is now, if she can't go home, now we have to look at other resources. So that's why I wanted to just jump in and say, even though this is a legal battle, Mary's still in that rehab and the insurance does not stop. So my question would be to you today is, do you know your insurance? Do you know what it covers? Days, you're allowed up to 100 days under the Medicare guidelines, right? But what does that look like? In between says up to 100 days. It didn't say that you can use 100 days. It said up to 100 days. And a lot of times people will come to me and say, my mom here, she came here on, January 1st, and we have until, April. No, you don't. Because the issue is this. If you have a Medicare managed plan like an Aetna, you know your United Health, if you have a Medicare managed plan, the insurance dictates your stay. There's a case manager like me who calls the rehabs, who calls the hospitals and says, hey, I know the patient's been in your rehab for a week, but guess what? We're going to deny the stay. So now instead of paying $200 plus a day after 3 weeks, you're full-blown private pay. And where I come from, full-blown private pay means it's now $600 to $800 a day because the insurance now pulls out. And if you don't have Medicaid here with CLIT, okay, guess what? Now you are full-blown. You don't have a secondary insurance that can cover a certain percentage while you're still waiting to figure out what your discharge plans with me. So we are all one. And that's why I always say, and Jocelyn said it best today, we want to be proactive instead of reacting at the last minute, because all certain things can't be avoided, but we can try to help prevent from what you're hearing now. So in this case with Mary and Bertha, unfortunately, as you can hear it, they weren't proactive. So that's just my spin on what I do. Yes?
Go ahead, Joy.
If you change the beginning of the scenario, would you all have advised that?
Oh, that's going to be the next question. How to prevent it?
No, I mean, because the life estate versus the trust, would you all have advised that Mary did a trust as opposed to taking a life estate in the first place? And so why?
All right. So she kind of preempted the next part. No, it's fine. It's fine. And just for everybody's edification, that's Joy Bunch. She's the vice president of programs for Amistad. So how could, okay, let's start with Mary since you brought up. How could these challenges have been prevented for Mary, the 93? What could she have done as the 93-year-old to prevent some of these issues?
All right. So I always defer to my smart partner.
Because you're smart. You're
The
smart.
smart
Happy
partner.
wife, happy life.
That's right. So what I like to say is you prepare for aging. So what that means is legally and financially speaking, what Mary could have done is created a plan for her aging. So in terms of her home. See, the thing about the home is, if that's the only asset you really have, right, you're not going to qualify for Medicaid, right? Because Medicaid only allows you to have under $32,000 in assets to qualify. But you will qualify because there's an exemption for the home. So, but what does that mean? That means that she can go into the care facility, Medicaid will pay for it, but the home is still in Mary's name, and when she passes in the nursing home, Medicaid is, by law, must recover against the estate. And they'll put what's called a Medicaid asset lien on the property. And so that would cause, so if she's in the nursing home, let's say for 2 years, that's in excess of $300,000. So now there's a $300,000 lien on the property, and can the family pay that? Most of the time they cannot. And so what they're forced to do is sell the property, pay off the lien, and then they get the rest of, if there's anything left over.
But if she would have had a trust?
Now, right, so pre-planning for Medicaid is when we like to call it planning vertically. Because if you're planning horizontally, then that's a crisis. You're already on your way to the nursing home. You're laying on your back. So when you're pre-planning, what you can do is if you're not in your 90s, you can say, listen, I've been at home, I've owned this home for so long. It's a family home. I want to pass it down to the next generation. I want the next generation to have it as well. You can create a trust, and there's a couple of different ways. If let's say in your 90s, you may want to just say, I just wanted to pass outside of probate. I'm going to stay here. I'm not going into a nursing home. I'm adamant about that. I only want to be cared for here. And you might not have the 5 years anyway. So you can there's a couple of different types of trusts that you can do. First is a revocable living trust, right? So it's an RLT. So it's like an open box. You can put your assets in there. You use it. You don't have to move. You don't have to go anywhere. But the title of the house. So we do a transfer deed. We do a new deed. And so the title of the house is the name of the trust, and you take it out of your name. And what that does is it allows the trust to control what happens to the house after you pass. So when you create the trust, you name a successor trustee, because in the RLT, the revocable trust, you're the trustee as well. You're the person who creates it, the grantor, you're the trustee, and you're the beneficiary, because you're using the asset, you're living there, nothing's changed. But when you die, you've already named a new trustee, just like you would name an executor in your will. It might even be the same person, but you name that new trustee, and that trustee says, okay, you've decided that this house goes to your daughter or whatever family members. That's what the trustee does. Then that trustee transfers the house to those beneficiaries.
So there's a difference between a trustee and a beneficiary.
Absolutely.
What's the difference?
So with any trust, there's three parties. First person is the grantor. That's the person who creates it, person that owns the assets that are going into the trust. That's Mary. So the second party is the trustee. Now, trustee is a fiduciary. What that means is somebody that's obligated to care for the assets on behalf of the trust. And that person is the person that manages the trust, makes sure the bills are paid, the utilities, all those kinds of things, the upkeep, the maintenance of the assets. And they follow the instructions in the trust document. And there's a lot of instructions that can be put in the trust document. Then the third party is the beneficiary. The beneficiary is the party that's ultimately going to receive the assets once the grantor passes away, or whatever triggers are in the document that say you can get, because there are ways that you can set up trust where you can give beneficiaries assets before you pass away. But for the most part, people do it in order to avoid the probate court and the surrogate's court and anything else. So that if the house, let's say if Mary decided that the house is to be sold and the money to be distributed amongst the children, then she could decide that, and that's what the trustee would do. Go ahead and put the house for sale.
Now, with the, going back to so let's just say, sorry. Let's start with the gentleman in the sweater on the left-hand side.
As far as transferring the deed over to the trust, would the bank give a hard time? Would it be like a lengthy process, or would they give you an issue in transferring the deed over to the trust?
The bank is not, there is a protections for everyone who wants to transfer a home into a trust, and the bank cannot impede that process. If you have a mortgage on the property, they are not permitted to call that loan, meaning they can't say, well, if you transfer it into that trust, then you have to pay the mortgage off. There is the, it's called the Garn St. Germain Act that says that the bank cannot do that. There are some specific conditions around that to make sure that applies, meaning it has to be your primary home. You have to still have the right to live in that home in order for that to be applied. But you can do it, and the bank can't stop you on that. However, if it may be different if you have a HELOC, right? That's a home equity line of credit. Now, with that, the bank can say, fine, you can put it in the trust, we're going to close the line of credit. They can't make you pay what you've already taken out on that line of credit. They can't make you pay it any faster than what was already agreed to, but they can close the line of credit so that you can't take any more. And then the other important distinction too, there are two types of trusts. Rob was describing the revocable trust, which is the open box, meaning you have the most flexibility. You can put things in, take them out. You can be the trustee. With that, banks don't have a problem with revocable trusts. They do have issues with irrevocable trusts. And so if you have property that you put into an irrevocable trust, then most banks will not then lend you any money on that property. They will, so you're kind of stuck. If you wanted to refinance a property, you need to do it before you put it into an irrevocable trust. Okay, there are some who will lend, but they're going to charge a really high interest rate, and the property has to be above a certain amount, in fair market value before they would even consider giving you that loan on an irrevocable trust. And the key, though, the important part to understand, it's only the irrevocable trust that you can use for asset protection and to plan for Medicaid to pay for your care. The way to get yourself qualified for Medicaid is to use the irrevocable trust. By transferring your assets in there, you're transferring them out of your name, so technically you don't own them. And if it's in that asset, we also call it the asset protection trust, right? Because you get revocable, irrevocable, you kind of get tongue-tied. So the asset protection trust is an irrevocable trust. And if you put your assets in there and they're in there for 5 years or longer, then you are beyond that 5-year look-back period for Medicaid. So it's as if an iron curtain comes down and Medicaid can't see all that stuff you put over there. So they're not going to count that as a resource. So that's the importance of pre-planning and doing it early enough so that you can have it in that asset protection trust for longer than 5 years.
Okay.
But, I'm sorry, I have Adam, but I will take the question first.
Well, this gentleman in the blue sweater also had a question. The red sweater, I'm sorry. Did you have a question in the blue?
Yeah.
Yes, go ahead.
You were talking about the person that, I guess, handles the trust. The person that handles the trust and the beneficiary, can it be the same person?
In a revocable trust, yes. In an irrevocable trust, it cannot be, you can be the grantor, you can create it, and you can be the trustee, but you cannot be the beneficiary.
In an irrevocable?
In an irrevocable. And for Medicaid purposes, you cannot be the sole trustee. So for Medicaid purposes, you can still be the grantor, you can still create it, and you can be a trustee with someone else acting as your co-trustee.
I think he said, can you be the trustee and the beneficiary?
Yeah, can that be the
Yeah,
same
and I said
person?
no. I said for the revocable trust, you can be both beneficiary and trustee, but for the irrevocable trust, you cannot be a beneficiary at all.
Okay.
Yeah, okay.
And I have a question that's something that was said earlier, if I may. You were talking about wills, and it was mentioned that the will would have to, do I understand that the will would have to go to court to make sure it's original?
You need the original will to go to court with. They will only take the original. And in fact, when someone does prepare a will, your attorney should alert you that you are to keep it bound. Do not take out any staples. It has to stay bound together in its original form, and that is what the court will accept. They're not going to accept a copy. There are some, there are ways to deal with that if someone only has a copy, and submitting an affidavit to explain what happened to the original and those kinds of things. But really, for the most part, it has to be the original will. But,
Okay.
We always say avoid court altogether. I mean, there's some wonderful judges like Judge Combs, right? But
I don't handle
stay out of
wills.
court.
Yes, stay out of court. The gentleman in the red shirt.
Yes, question. I'm a power of attorney. Do I need a trust or a will?
You are a power of attorney?
Yes.
So you're somebody's agent.
Okay.
So somebody wrote a power of attorney and gave you the ability to represent them on their behalf. Is that what I'm understanding?
That's correct. My mother, she has dementia.
Okay, so you're her
That
power
was about 30
Okay.
years ago. Now, going forward, do I need to be proactive on anything?
That's a great question. That's a great question. So one of the things that you want to make sure is, as your mom gets older, it's great that she gave you power of attorney, because now you can go to the bank, you can deal with her insurance, you can deal with folks like Tiffany and all that to make those decisions. The one thing that you want to check is to be sure is if she's given you the power to do estate planning for her, so that you can create a trust. So a power of attorney can create a trust and do estate planning for the incapacitated person. And so you want to make sure that's in there. But here's the thing. A lot of times people get power of attorneys from online, and they have a lot of space on them. It's like what we talked about with the healthcare proxy. There's a lot of empty spaces on there, and the power of attorney has a long list of things that a power of attorney can do. And if they're all not initialed, or there's one at the end that says, I want to give all these powers, that's P, and you put your initials there, that's still not everything, because estate planning is not part of that. So what's there is a modification section, and that's very open. And if you don't know, and if you're doing it yourself, and you don't fill anything in that modification section, you don't have the right as the agent to do estate planning and create that trust. We specifically put it in so that if there is any changes that are needed to an estate plan or a trust plan or things like that, the agent can do it.
Okay, we have a question here in the front. Let me give you the mic so they can hear you over there.
Okay, I have a two-part question because of what you just said. The first one is, my father is deceased, and there's a will that my sister had, but then she died. So now I was able to secure a copy, so you said that I can try to work with it some kind of a way? Is that what somebody said?
Well, if you only have a copy of the will, and the original can't be located,
Right.
Or do you know what happened to the?
She was a hoarder. I ain't find nothing.
And you couldn't find it.
Yeah.
Okay.
She didn't hoard the right
She didn't-
Yeah, yeah.
So there's an affidavit process that you can use
Okay.
to explain where the missing will is.
Okay.
And it depends on the situation. You don't always have to probate a will.
Well,
Depending
I'm
upon-
also in the middle of becoming the executor to the estate because she lived in my father's house. So I'm in the middle of becoming an executor to the estate. So do I just wait for that and let that be the bottom line of it?
Well, you need the will to become the executor. So if you only have a copy, you're gonna have to explain to the surrogate why you only have a
I
copy.
gave them everything. She never addressed that. It was just a copy.
Yeah, you might need to talk.
Okay, so the second
after.
question is, I want to put that same house in a trust. Do I need the revocable or the irrevocable?
Well, the only person that can put a home into a trust is the owner. So right now, the estate is the owner, so you don't have that right to do it yet. So it's an open estate.
Are you the beneficiary under the will? Are you gonna be receiving that home?
I'm the beneficiary under the will, but if I can't find the original, how does that work? Well,
Right.
she died.
But we don't know the specific, we don't know.
She died. Okay, so right
So
now,
let's do this. So I think that you need to consult with an attorney. You can consult with us because you have a specific family situation that needs a little more exploring because we don't know the makeup of your family and what other siblings you might have because those are the ones that are going to play a role in this. I don't. Okay. So then, there's different ways. There's another way that you can do this.
You can still answer the question, not necessarily personally for her, but when do you need a revocable trust and when do you need an irrevocable trust? That was essentially what you were getting at, right? And so it depends on there's that answer again, right? It depends. But it depends on what your goal is. And somewhat what your age you're at too, right? Because we recommend looking at that irrevocable trust, that asset protection trust, when you're closer to your past retirement age and you're doing that Medicaid pre-planning. Because it's there, you want to put your assets in there so that they're there for the 5 years to get yourself in a position to be able to qualify for Medicaid. If you are not yet retired, and you still want to have full control and flexibility over your assets, if you want to refinance for some reason, you want to do some house renovation or whatever, you want to then stick with the revocable trust, the RLT, Revocable Living Trust, because then you can do whatever you need with that without any restrictions. But both trusts are going to allow you to avoid probate, and that's what you really want to do. Remember, a will equals probate. And let me talk about probate for a quick second in terms of the cost of probate. Because a lot of people, you'll go and you'll see the price points when you go see a lawyer. The will is the least expensive as compared to the trust. It goes will, revocable trust, irrevocable trust, right? Because you're getting more with each step. So it's going to be more as you go up. But you have to remember, that's somewhat of a myth, and here's why. That's the cost to create those documents. But what is the cost to implement those documents? When the will has to be implemented, you're going through probate, for the most part, attorneys charge, on average, 5% of the value of the estate. 5%. So let's take a house that may be worth, anywhere from $500,000 up to $1 million, depending on where you are in Long Island. Maybe you have retirement assets or maybe some investments. But just for the ease of math, let's say the estate is worth $1 million. And it's not far-fetched. I know it's, when we were growing up, $1 million was like you were rich, but these days you're not rich anymore. But $1 million estate, 5% of that is $50,000. So that will cost you $50,000 plus the cost to create it. So you have to keep the other number in the back of your head. What is it going to cost your family, right? Now, for a trust, you create the trust, and as I said, the revocable trust is going to cost more than a will, and the irrevocable is going to cost more than the revocable. When your family or your trustee, it comes time for your trustee to implement the terms of that trust after you pass, it doesn't cost them anything. They don't have to take it to court. They don't have to tell anybody. All the trustee has to do is start, you said, what's the kids' names? I don't remember now. And, right? Nevaeh, of course, heaven, right. Nevaeh is going to receive her check or whatever she's supposed to get. The trustee just writes it out and gives it to her. She doesn't have to get permission from anyone, go to anyone. So there's no cost on the back end. So now when you think about it,
what is really the least expensive? It's really not the will, right? And then you have other benefits that come with the trust. He's correcting me to say it's not completely no cost. I mean, it's not totally free in the sense that there may be some steps that the trustee has to take to just, if they need to get a tax return prepared for the deceased or anything like that. It's going to cost a little bit, but it's not going to cost you $50,000, right? To start. So that's an important distinction. And then I know, yes.
Yes, could you tell me, is it important now trustees be on the bank accounts and savings accounts?
Well, the trustee is only going to be on the bank account if you have a trust created. So then what you're putting the bank account in the name of the trust, and so your trustee has control over that bank account. But here's the thing, I do not advise that you put your regular checking account into a trust. I mean, you can do it in a revocable trust because with a revocable trust, you can move things around. It's like nothing, right? You can do that. The main benefit of the revocable trust is avoiding probate. But if you are working with an irrevocable trust, then you want to keep your regular personal checking account separate, keep that in your own name. And you're using that just to pay your bills and your expenses. You can keep some money in your savings account, but remember that threshold for Medicaid purposes is $32,000, right? $32,000. So you don't want to have more than that in your savings account. And I would say, keep even less, have a little room. So you can keep your personal checking and small savings, right? I'm saying small relatively because $30,000 is still a lot of money. But if you have investments beyond that, put that investment account in the trust, and because then you're protecting it. And one other thing to understand about irrevocable trust, because people get a little scared of them because they think they lose complete control. It's not the case. So what you're doing is you're protecting that asset for your loved ones to make sure it's there intact for them when you pass. Can you use any of it? Some part of it you can. Let's say you have a property and you have rental income from that property. That property's in the trust, you can take the rental income and use that for yourself. So to that point, you are somewhat still a beneficiary in that sense, right? You can take it, you're called an income beneficiary. And then if you have, let's say, an investment account, Charles Schwab, Merrill Lynch, whichever company you're using, and you have stocks in there, or your mutual funds in there, the ETFs, any gain on that you can take out and use for yourself. You just can't take the original underlying asset or the original piece of property back out. You're safeguarding that for your loved ones, but any income that it makes, you use it for yourself now, and that's perfectly acceptable. So you can be an income beneficiary, but not a final beneficiary.
All right, I'm going to just take 2 more questions, and I just want to say that we are going to allow the panel to speak to the audience one-on-one if there's any, personal things you want to ask. But
I have a question. We heard about revocable trust, irrevocable trust. Is there such thing as a living trust?
The whole category is actually called living trust.
Oh, okay.
Right?
So it's not a separate thing.
It's not a separate thing. The revocable and irrevocable, they are living trusts. And it just means that it's created while the person is still living. Right?
Okay.
The other type of trust is a testamentary trust. That's created through a will after somebody dies. So that's why they call it a living trust, because while you're still, kicking and breathing, you create the trust.
Okay, I have just one part. You said that the irrevocable trust would be around retirement, but is there an age limit? I mean, what if you've been retired for 10 years and you're 75?
Okay, so that's fine. There's no age limit. It's just
okay.
A lot of times people ask, well, when should I do this one? When should I do
Right.
that one? And generally, we sort of just loosely say retirement age, generally being 65, 70, right? These days, they don't want to let you retire till you're about 80. But, because when you start getting to those years and the medical issues start creeping up, you just want to make sure your plan is in place. But there is no age requirement.
First of all, thank you, panel. This has been great information. My mother's in a situation where her siblings have come from Nigeria here, and they have their family, their spouses still in Nigeria, but they're here. And now, given this conversation, I'm concerned about how to set up their healthcare proxies. One of my aunts wasn't feeling well, soon after she got here. She got better, but it's like, okay, how do I prepare my mother to address any health concerns or that might come up the easiest way? How does the fact that their spouses are in another country affect what she can do, I guess is my question.
I say it starts with you first. It starts with you first, because for you it could be a sensitive topic to approach your mother. You know her best, right? So a lot of times the adult child may be sensitive to it according to the expectations or the thought of how mother is going to perceive it. So by you getting educated, understanding it, it'll allow you to understand how to approach your mother so you can connect with a team like this where you would be of an asset to your mother. So it starts with you, so what you're doing now.
We have one more question over here.
I don't think she finished the answer.
To add on to. That was more mental health for you.
No, sorry.
No, well, the only thing to add on to that really is the healthcare proxy and a power of attorney can be anybody. It doesn't have to be a sibling, doesn't have to be a spouse even. It's somebody that you trust. So if she puts all of her trust in you, then it could be you. And that's how the thought process goes. But as Tiffany said, that's a conversation that you guys have, and you deal with it.
But having it be someone that is out of the country can be a challenge, and so it would be advisable to have somebody that is here.
Now, which one did you say, the revocable trust or the irrevocable trust that you cannot, the grantor cannot take money out of while they're still alive?
It's the irrevocable trust. The grantor can only take income out of it while they're alive. So it has to be an asset, whatever asset you put in there, if it's one that generates income, they can take the income only.
All right. Whew. That was a lot. I'm just going to ask one more question, and then I'm going to let everybody have an opportunity to meet you up close and personal. And I think that this is a fair question for me to ask because you did put it all over the airways. Rob and Sharon, could you please share how you came to start doing this work?
So my grandfather had 12 children. He's born and raised in North Carolina. During his life, he was able to purchase land and owned land, about 11 acres in North Carolina. And when he died, he did leave a will naming his 12 children as the beneficiary of this land. That's it. No instruction, no more guidance as far as what to do with it, how to divide it between them, or anything like that. And he died about 40 years ago. So that land is still sitting there because the 12 siblings could not agree on what to do with the land. Some wanted to sell it, some wanted to carve it up and take a piece, but part of it is swamp. Other part is good farmland. The other part, they have different values depending on if you try to split it up. So for these 40 years, the family members, those 12 siblings, have been, at odds with what to do with that. But here's the other twist. The 12 siblings, that's, my mother's age group. My mother is 91 years old, right? Now, she was somewhere in the middle of those 12 siblings. So a number of them, 8 to be exact, have passed. So there are 4 left. Those 8 had children. 2, 4, 6, 10, right? A lot of children. So every time one of those siblings pass, their children move into their spot. So now today, it requires about 39 people to agree on what 12 people couldn't agree on 40 years ago, right? So seeing all that happen, and I don't know what's gonna happen. And my mother's still alive, right? My mother had 6 children, so we're gonna be added to the mix, right? We'll be in the 40s as to who has to agree. So hopefully, eventually, one day it'll get worked out. But I wanted to avoid that from happening again. So when my mother and father owned commercial property, and my father passed, and that went fine. Everything went to her. But now she wanted to make sure she had a plan so that we weren't saddled with the burden of our disagreements and trying to figure out between the 6 of us what to do. So I knew that a will alone wasn't going to be the answer, because I can tell you now the 6 of us don't agree. And although, you know, I'm the youngest, I'm clearly the smartest, but I digress. But I wanted to make sure that was avoided, so I made sure to find an attorney, because at that time when we did this, we were not practicing in this area. So we found an attorney to create a trust for her. So she is set up with a trust, an irrevocable trust, because we also were mindful of her age and the possibility of needing long-term care. Thank God right now she's, you know, fine. But we wanted to be able to, if we need it, be able to qualify for Medicaid in the future. So we set her up with that, and going through that process, we also did the same thing with his mom, and going through that process and talking to that attorney, who was another attorney of color, she encouraged us to go into this area, and we did. Seeing, you know, what the horror stories have been and experiencing my own family's situation, we wanted to be there to share the information with others and help them avoid some of the problems and pitfalls that happen. And then one of as I said, we did it with my mother-in-law, with his mom, and she passed about 2 years ago, and she had a trust as well. And through her trust, we were able to see and validate how it worked so smoothly, because there was no court involvement. The instructions were there in the trust, and it was a easy process. So the only thing you had to do was grieve the loss of your loved one and not have to fight over money and figure out who's going to get what. So that was validation for us that it works, and it is the best course of action to take. And we were in the course of even going through the Medicaid application process, but unfortunately she passed before we even got there. But that's how we ended up doing this work. And I do want to say too, it's never too late. It's never too early, and it's never too late. But the later you wait, the less options you have, right? So even if you didn't do anything yet and there's a crisis situation, there are still things that we can do to help safeguard a good portion of your assets. You know, it may not be as much as if you had come earlier, but there's still something that can be done. So never just sit on your hands and wait.
Right. One thing that Bishop Willie preached in 2018 when there were pews here and I was sitting over there, he said, never let fear cause you to lose your focus. This is a very scary, overwhelming process, but it's something that has to get done. And my personal experience going through it with my parents, I think it took us about 4 years before we signed everything, because when you're sitting there and your parents tell you things like they don't want a DNR, you want to stop the whole process, right? Because your sentiment is, I'm going to give my life, I'm going to give along before my parents transition. But, it starts the conversation to hear about what their last wishes are, what it is that they intend for their children, stepchildren, grandchildren, like children. People jump up and down all the time. I was like a son to them. I should be in the will, but you're not, okay? And what we hear in the community, right, Bishop Willie? I know that they left something for me. I know they left something for me. They're lying. Just get it all out. It's like, what do they say? You pay now or you pay later, and you always pay more later. So I just want to thank the panelists again. Can we give them a round of applause? And I just want to thank everybody for coming out and taking the initiative to get there, to make sure that their affairs are in order. And this is something that Amistad does every year. For over 20 years we've been doing this day of service on MLK Day. And we do have a sign-in. So if there's like something that you would like us to do another panel on, could you just put that at I think the last box asks you, because we're doing something on immigration in Elmont with TPS expiring for the Haitian community and I think some African countries. So we'll be doing something on TPS on January 29th. I'll get that information to Bishop Willie. We've done family law, we've done criminal law, we've done tax grievances. So Amistad has self-identified itself as the legal voice of the Black community. And what we really want to do is bring information to you so that your rights could be protected on every level in every facet of your life. So with that being said, we're going to allow the attorneys maybe to go in the back corner, and maybe Tiffany, the back left corner. Tiffany could go to the back right corner. Clint could be over here in the right front. Jocelyn could be in the left front. So if you have any personal scenarios that you wanted to share, you could speak to them directly. Also, could we just give a round of applause to the shepherd of this house, Bishop Walter C. Willie? You could do better. We had the opportunity to live stream this for people who weren't able to come out. And I just want to thank you for always being there, not only for Amistad, but for the community. He is not only a shepherd of this house, but he is a shepherd of this community to make sure that people are surviving and thriving in this day and age. And we appreciate you, Bishop. All right, can we just get a closing prayer?
So I'd like to give my closing prayer. Thank Judge Victoria Gumbs Morgan. Come on, show some love, y'all. The Amistad President, Diane Clark, God bless her. And the panelists today, God bless y'all today. There's also some other Amistad lawyers here over there. And so today, y'all have many questions. Today's seminar was fantastic. Well, like me and like y'all, we're saying y'all are lawyers and we know speak your language. And you'll give us so much information, but we're just trying to process what was said on today. And we need many more seminars like this for our communities, because it takes some of us a little time to really digest what you're saying. You know, when you get a certain age, your listener is not as shocked as you was when you were 20 and 30. And so a lot of people here today, I'm looking around today, many of us today are over a certain mark. I'm going to leave that alone. So you're saying, preacher, we videotape this, y'all. So those who want to videotape, let us know. You can get a copy of the videotape. You can always look at it later on at your disposal. But I want to say thank you again, Amistad, for doing a wonderful job here in this community all over Long Island. We need y'all. Because I use this top all the time, get your house in order. And it's part of getting your house in order, the legal information for our people. Thank you again, praise God. And when they're going to be all over the place, y'all ask them questions. I know you're asking all kinds of questions. But just ask them questions and they can tell you where to go, okay? Thank you again.
We have two other members from Amistad. Could you just stand up for a moment? Well, one member and one future member. So if you have other questions that don't have anything to do with trust and estates and you want to talk to them, oh, and also Diane, if you want to stand up, if you have other questions that don't have anything to do with these topics, you could talk to them and they can give you some information, okay?
All right, so they're going to go all over the church and you go to them individually and ask them questions. We got another, whatever when they want to leave. Downstairs, a little, something downstairs. I don't know, something downstairs, okay? But enjoy the moment. If I were y'all, I picked it. Yes? You said it's flipping up. Who's talking about what class? I don't know. I can't tell you that.
What are those three talking about?
And then you got Diane over here. What you whatever. Taxes or criminal law or immigration or whatever. Family law, see them over here, okay? All right? God bless y'all. Lord, we thank you again for this moment of sharing, receiving information. Thank you again for the panelists, for your people. Continue to give us clear understanding for these moments. We bless your name. We say amen. Come and see them right now. Enjoy the moment. You could cut it off now. Thank you.